One branch of the United States government has just moved to limit a sitting president's authority over the military inside the country. Washington District of Columbia, 10:42 in the morning. An emergency ruling from the Supreme Court of the United States has just been released. The vote 6-3. The decision places immediate limits on the ability of President Donald Trump to use federal military authority in a domestic deployment tied to a federal security directive. Pause on that for a moment, because this is not a routine legal dispute. This is not a policy disagreement. This is a constitutional pressure point between the executive branch, the judicial branch, and the federal system of the states. And the system reacted almost instantly. Within minutes of the ruling, 27 state governors announced the formation of what they are calling a federal resistance bloc. Their declaration is simple and direct. They say their states will refuse to cooperate with any federal military deployment orders connected to the disputed directive while the legal fight continues. Let me say that again so it lands properly. The Supreme Court restricts a presidential military action, and more than half the nation's governors organize a coordinated response. That is not normal. That is the architecture of American federalism moving in real time. Now, here is where the institutional significance begins to sharpen. The Supreme Court did not simply interpret a statute or schedule a hearing months from now. The court intervened immediately, and it did so through a mechanism known as an emergency constitutional review order. This is a procedural tool that exists inside the court's emergency docket. It is rarely used, and when it appears, it usually signals that the justices believe something inside the constitutional system is moving too fast to wait. In practical terms, the order temporarily limits parts of the presidential directive connected to federal troop deployment inside the United States. It does not cancel the directive entirely, but it freezes certain enforcement powers until the legal challenge is fully reviewed. That distinction matters, because it means the court has effectively stepped into an active executive decision and placed a constitutional guardrail around it. This is where you need to understand the context. The chain reaction started with an emergency executive security directive issued by President Donald Trump. According to the directive, federal forces could be deployed to support a domestic security order connected to federal enforcement priorities. But several states argued that the directive crossed a legal boundary. Their claim was not primarily political. Their argument was procedural. They said the order exceeded the statutory limits of federal authority and failed to meet the legal conditions required under existing domestic security laws. So a coalition of states filed what they called an emergency constitutional challenge in federal court. And the timeline that followed moved at extraordinary speed. District court filings, immediate appeals, emergency motions. Within 48 hours, the dispute landed directly on the Supreme Court emergency docket. And now, the first official confirmation has arrived. The clerk of the Supreme Court released a formal notice confirming the 6-3 decision. The order temporarily restricts elements of the executive directive connected to federal troop deployment while the case proceeds toward full constitutional review. This is where the system reveals its deeper mechanics, because what the court has triggered is not just a ruling. It has activated several of the most sensitive legal mechanisms inside the American constitutional framework. Judicial review of executive authority, federal versus state power, and the constitutional boundaries surrounding the president's ability to deploy federal forces domestically. Those are some of the most contested powers inside the entire structure of the United States government. And the central institutional actor right now is CSIR, the Supreme Court of the United States. Its authority in this moment is not political persuasion. It is constitutional interpretation. The court can interpret the Constitution, it can review executive actions, and it can issue orders that immediately bind the entire federal system. If the court changes its position later, the balance of authority could shift again. But right now, the ruling stands, and that is why the reaction from the states arrived so quickly, because something larger than a policy dispute is unfolding. Look at the scale of the institutions involved. The President of the United States, the Supreme Court of the United States, and 27 state governors acting in coordination. Executive power, judicial review, federal state authority. 3 layers of the constitutional system now intersect in the same moment. Here is the gravity of that intersection. Domestic military authority has always been one of the most sensitive powers held by an American president. Every time it is invoked, the legal boundaries are scrutinized. Every time it is challenged, the courts move cautiously. But this time, the court moved quickly, very quickly. And when that happens, it usually signals something deeper inside the institutional system. This is where the story shifts from a single decision to a system-level stress test, because now three centers of power are under tension at the same time: the presidency, the Supreme Court, and a coordinated bloc of states. And if this ruling holds even temporarily, the next phase will not just test the law. It will test how the entire federal system responds when its most powerful institutions pull in different directions at once. The procedural chain that led to the 6-3 ruling moved through the federal system with unusual speed, each institutional step tightening the legal boundaries around the original directive. The first move came from the executive branch. Earlier in the day, President Donald Trump signed a document titled the Executive Emergency Security Directive, authorizing the potential deployment of certain federal forces within the territory of the United States under emergency security authority. The legal justification referenced the president's constitutional role as commander-in-chief, along with statutory authorities tied to the protection of national order. That directive immediately triggered a legal response from the states. Within hours, a coalition of states filed suit in federal district court, arguing that the directive crossed constitutional lines between federal authority and state sovereignty. Their filing requested an emergency injunction designed to temporarily halt any deployment until the legality of the directive could be examined in full. The filing signaled that the conflict had already moved beyond routine political disagreement. Multiple states joining a coordinated emergency action suggested the dispute was evolving into a structured institutional confrontation inside the federal system. The case quickly moved upward. Attorneys representing the states brought the dispute before the Court of Appeals, asking the appellate court to immediately suspend the directive while litigation proceeded. The appellate panel reviewed the request, but declined to issue an immediate stay. The reasoning was procedural rather than political. The judges indicated that the constitutional questions raised by the directive were significant enough that they might ultimately require direct evaluation by the highest court rather than a temporary appellate intervention. That decision opened the next legal pathway. The case was then filed on the Supreme Court emergency docket, a rarely used procedural track that allows the court to intervene quickly when a dispute carries immediate constitutional consequences. Emergency docket cases have the ability to reshape federal authority almost overnight, and that is what happened here. After reviewing the filings submitted by both sides, the Supreme Court issued a 6-3 decision temporarily limiting the president's authority to implement the directive until further judicial review takes place. The ruling did not resolve the entire constitutional dispute, but it immediately changed the legal environment surrounding the directive. Once the court intervened, several legal doors began to close. First, the immediate authority to deploy federal forces under the directive became restricted. Key operational aspects of the order are now paused, while the judiciary examines the constitutional boundaries involved. Second, the executive branch is now required to wait for a full judicial review before attempting to restore the directive's original scope. That review will involve detailed constitutional arguments about the limits of presidential authority in domestic security situations. The practical consequence is straightforward. Operational plans connected to the directive cannot move forward unless the courts allow them to proceed. At the same time, a third development began to emerge from the states themselves. Several governors indicated they were reviewing mechanisms of state self-governance within the federal system. These tools are designed to protect state jurisdiction over internal security matters when disputes arise with federal authorities. These signals are not merely rhetorical. They represent states positioning themselves within a constitutional dispute that remains unresolved. Taken together, the result is a narrowing field of action for federal authorities, not through political negotiation, but through the structure of the legal system itself. As the Supreme Court ruling circulated through Washington, responses began forming across multiple branches of government. At the White House, officials confirmed that the administration is reviewing its next legal options. Those options may include refining the directive, submitting additional legal arguments, or preparing for the next phase of judicial review. The executive branch has not withdrawn its position. Instead, it is preparing to defend the directive in the next stage of litigation. Inside the Department of Justice, attorneys are assembling a petition for expedited review. Such a petition would ask the Supreme Court to move quickly toward a full hearing rather than allowing the litigation to stretch over an extended timeline. Speed now carries strategic importance. The longer the directive remains legally constrained, the more institutional pressure accumulates across the federal system. Meanwhile, several congressional leaders have begun calling for oversight hearings on Capitol Hill. These hearings would focus on the legal foundation of the directive and the planning process that preceded it. Congress does not directly control the judicial proceedings, but through oversight authority, lawmakers can place executive decision-making under examination while the legal battle continues. At the same time, the federal judiciary is preparing for the next procedural phase of the case. Legal briefs are expanding, constitutional arguments are being refined, and preparations are underway for a full constitutional hearing that will examine the directive in detail. In other words, the institutional system is now fully engaged. Executive authority has acted, judicial review has intervened, legislative oversight is beginning to mobilize. All three branches are operating within their constitutional roles at the same time. At the center of the dispute lies a fundamental constitutional boundary. Where does the president's authority to deploy federal force within the country actually end the Constitution? Designates the president as commander-in-chief of the nation's armed forces. That authority is broad, but domestic deployment has historically operated within a framework of statutory limits and legal triggers. The present dispute raises the possibility that those limits are once again being tested. Another constitutional boundary concerns the rights of states to decline cooperation with federal actions. The federal system preserves significant authority at the state level, particularly in matters connected to internal governance and public order. A third boundary involves the power of the judiciary itself. Federal courts possess the authority to review executive actions when constitutional disputes arise, but the scope of that intervention is often debated when national security powers are invoked. History provides partial comparisons. There have been past conflicts involving presidential emergency authority. There have also been disputes over state resistance to federal directives. However, the present configuration remains unusual. Multiple states challenging a domestic security directive while the Supreme Court intervenes through its emergency docket creates a situation without a fully identical precedent. That is why many legal observers describe cases like this as boundary tests within the constitutional system, moments when the edges of institutional authority become visible. Looking ahead, several developments may shape how this confrontation unfolds in the coming weeks. A full Supreme Court hearing could take place, allowing both sides to present extensive constitutional arguments regarding executive authority, federal power, and the rights of the states. Congressional investigations may also begin if oversight hearings move forward. Lawmakers could request testimony from officials involved in drafting and preparing the directive. The Department of Justice will continue developing its legal strategy as it attempts to accelerate the court's review process. And the coalition of states is expected to expand coordination as attorneys general and governors align their legal positions for the next stage of litigation. All of these developments could occur within a relatively short period of time, weeks rather than years. Each procedural step carries the potential to reshape the legal boundaries involved in the dispute. And for the moment, one conclusion is difficult to ignore. The constitutional system of the United States is now operating under a visible institutional stress test. Several indicators will now determine how this constitutional confrontation evolves in the coming weeks. Each signal will reveal whether the system is stabilizing or moving toward deeper institutional friction. The first indicator is whether the Supreme Court decides to schedule a full constitutional hearing. The emergency ruling temporarily limited the directive, but a complete hearing would bring the entire legal question before the court. If such a hearing is scheduled quickly, it suggests the judiciary intends to define the constitutional boundary directly rather than allowing the conflict to remain unresolved. The second indicator is whether the White House chooses to modify the executive emergency security directive. An adjustment to the order could narrow the scope of the dispute and potentially reduce the constitutional pressure currently building around it. Even small revisions in the language of the directive could shift the legal arguments that now dominate the case. The third signal will come from Capitol Hill. If congressional leaders move forward with formal investigative hearings, the dispute will expand beyond the courtroom and into the legislative arena. Congressional oversight would introduce additional scrutiny into the legal reasoning behind the directive and the process through which it was developed. A fourth indicator lies with the states themselves. At this moment, 27 governors have formed a coordinated resistance bloc. If additional states join the coalition, the dispute could evolve from a legal challenge into a broader federal alignment of state authority. The larger the coalition becomes, the more weight the states collectively bring into the constitutional argument. The fifth signal concerns the legal strategy of the Department of Justice. Federal attorneys may choose to adjust their arguments as the case moves toward a full hearing. A shift in legal reasoning could indicate that the administration is attempting to redefine the central constitutional question rather than defend the directive in its original form. The sixth indicator will come from the lower federal courts. Additional injunctions could appear as related cases emerge across the country. If district courts begin issuing new rulings connected to the directive, the legal landscape could become more complex before the Supreme Court resolves the issue at a national level. Together, these six indicators will reveal the direction in which the institutional conflict is moving. From here, several different scenarios remain possible. One potential outcome involves a gradual institutional de-escalation. In this scenario, the administration modifies the directive while the courts narrow the scope of the dispute. A revised order combined with judicial clarification could reduce the immediate tension between federal authority and the states. Another path would involve procedural escalation. Congress could open formal hearings, additional legal challenges could emerge, and the dispute could expand through multiple branches of government simultaneously. In such a scenario, the constitutional question would remain active across the courts, the legislature, and the executive branch at the same time. A third possibility points toward a deeper constitutional confrontation. If the conflict continues to intensify, more states could join the existing coalition of governors, and the dispute could become a prolonged clash over the limits of federal authority. Under that scenario, the legal battle might extend well beyond the current directive itself and into broader questions about the balance of power within the American system. The consequences of the case are not limited to the courtroom. Its impact may unfold across several dimensions of the national system. From a legal perspective, the case could shape a new precedent regarding the limits of presidential authority in deploying federal forces within the country. Courts may ultimately define more precise boundaries governing how emergency powers can be used in domestic situations. From a national security perspective, the ruling already affects the mechanisms through which federal forces may be deployed in response to internal threats. Any new legal standard emerging from this dispute could influence how future administrations plan and authorize domestic security operations. The political consequences are also significant. Tension between the executive branch, the judiciary, and the states may intensify as the case unfolds. Such tension can reshape the dynamics between institutions that are normally designed to balance each other. There is also a potential electoral dimension. A dispute involving presidential authority, state resistance, and Supreme Court intervention could become a central subject of national political debate, particularly if the case remains unresolved for an extended period. Beyond the borders of the United States, international observers are watching how the American constitutional system responds to internal institutional pressure. Allies and strategic competitors alike often view moments like this as indicators of how resilient the United States system of governance remains under stress. Ultimately, the confrontation now unfolding raises several fundamental constitutional questions. Where exactly does the real boundary of presidential authority lie when federal power is invoked inside the country? Can the system of checks and balances absorb sustained pressure when multiple branches of government and a coalition of states are involved in the same dispute? And perhaps most importantly, can the constitutional framework of the United States recalibrate itself when confronted with a conflict of this magnitude? For now, none of those questions has a definitive answer. They remain open inside the institutions that now hold the next steps in their hands.